Most people are familiar with the 5 kids wrongly convicted in the Central Park jogger case back in 1989. They would go on to be known as the Exonerated 5 and the subject of Ava DuVernay's movie When They See Us. Interrogated by police and detectives for more than 24 hours, all but one ended up falsely confessing to a crime they didn't commit. The docuseries heightened public awareness of how police interrogate children, but sadly, very little has changed in the 30 years since the Central Park jogger case. Tonight, we discuss strides made to change these interrogation tactics by police in Illinois and New York, and we'll also look at an actual video showing exactly how police operate when interrogating kids. In fact, let's show a clip from the specific interrogation we're talking about.
Everyone's predicament. Talk to me. You got your mom down here. She's trying to be concerned what's going on with you. You're already in the situation. So you say you was at the store, right? Officer approached you, got into the situation.
With me to discuss is Marty Feinman, head of Juvenile Delinquency Training at Legal Aid Society's Juvenile Defense Practice in New York, and Cheryl Dorsey, a retired LAPD Sergeant. Thank you both for coming on. You just saw a brief excerpt from the video involving a child that is represented by you, Marty, and I'll get into that with the both of you, but first to you, Cheryl. So many people have no idea that cops can lie to them. I mean, that lying is a legally permissible interrogation technique, and not just for questioning adults, but also kids. In the Central Park jogger case, for example, they told one of the boys that his DNA was on the jogger's clothing. Why are police allowed to lie in an attempt to get to the truth, ironically, when we know that that technique elicits false confessions more times than not?
Well, I don't know exactly why they're allowed to do that, but this has been a long-standing practice. And for anybody who's watched, cable television, there's been a long-running series that shows police officers doing that very thing. And that's why so many times people need to understand that really your best interest is to say nothing, whether you're a juvenile or an adult. And we are going to see in this video that this officer, this detective, is being very savvy in the way in which he gets this young man to speak by using his mom. Because after all, moms will say, tell me what happened and I want to know the truth. And you're going to say whatever you need to do to please your mom and thereby give this officer the information that he needs that he currently doesn't have.
We're going to actually get into that, but you definitely alley-ooped into my next question. Marty, most people understand the idea that adults shouldn't speak to police without a lawyer, even if that's not what they do in practice. But somehow when it comes to children, people tend to think that having their parents present is enough. Please tell us why children need a lawyer just as much, if not more, than adults when being questioned by police.
Well, sure, thank you. I mean, obviously, they need an attorney more than an adult does. The reality is that, most people understand that in the abstract, but when it comes to the practice, most people don't. And that's evidenced by the high rate of confessions, even by adults, when they're being interrogated by police, waiving their right to remain silent. But what we know from social science, what's become abundantly clear over the last 30 or 40 years, and which we've also learned from experience, is that developmentally speaking, adolescents are not in a position to be able to process the information, to be able to fully appreciate the abstract nature of what the right to remain silent means. They don't understand what the potential implications of waiving that right to remain silent are. They are very, very, very susceptible to police coercion and the kind of deceit that you asked about in the first question, which is permissible, quite frankly, primarily because it's effective, because the police are trained to use deceit in an effort to obtain waivers and obtain confessions from people who don't fully appreciate what's going on. And juveniles, more than anybody else, in order to compensate for these developmental limitations, really need the presence of an attorney. And I emphasize an attorney, not just an adult, because we know, and the Exonerated 5 case is a perfect example of this, we know that even the most well-meaning adults, the most well-meaning parents who want nothing but the best for their children, are no match for law enforcement who are trained to co-opt them in an effort to get them to work unwittingly as assistance to law enforcement in an effort to get youth to confess, which is exactly what people saw a bit of, and I'm not sure if you have more of the clip, but would see more of in the clip that you
Yeah.
have used as an example here.
Yeah, we're definitely going to get into more of that
Great.
video. Now, you
Great.
drafted legislation, Marty, in New York
Yes.
that would make sure children are afforded the presence of counsel. Can you tell us more about that?
Sure. Myself and a number of my colleagues drafted some legislation, which is being sponsored in the New York State Assembly by Assembly Member Latoya Joyner, and in the Senate by Senate member, Jamal Bailey. It's the same bill in both houses, and essentially it's a bill that will mandate that before the police can interrogate any youth, the youth must first consult with an attorney, no matter what time of day, no matter what time of night. And it's not a function of the youth saying, yes, I do want to talk to an attorney. The youth will have to speak to an attorney before there can be any waiver of the critical Fifth Amendment right to remain silent. An attorney who's trained in this kind of work, who can advise the youth, who can explain to the youth what the waiver means, and who can provide the youth with intelligent advice as to whether or not it's to the youth's benefit to waive that right to remain silent, which as I'm sure most people appreciate, it virtually never is. And I should go on to say that if the police were to violate that right, the statement would be suppressed. No statement could be used against a youth if they did not comply with that requirement.
I see. Okay. Well, let's get back to the video and play the first two clips showing a 13-year-old boy being interrogated by police in New York last year. The first clip is pretty short.
If you do not have an attorney available, you have the right to remain silent until you have had the opportunity to consult with one. That means if you want a lawyer, but a lawyer is not here right now, we will wait to speak with you until a lawyer can get here. Do you understand? Yes. All right, now that I've advised you all your rights, are you going to answer any questions?
Depends on what they are.
No, it's either yes or no.
Yes or no? No.
No?
No.
All right, cool. Give me 1 second. Hold on.
Okay, so Cheryl, that should have been it, right?
Absolutely. I mean, he said he didn't want to speak, and so now you see that this officer leaves the room because he doesn't know what to do. He wants that statement, and he's got to try to figure out, how do I get it? And so obviously he went out to tag somebody to figure out, what do I do? And they said, go back in there and just keep talking to him, and use the mom, who was not as savvy, to see if he'll talk to her. He's not talking to you, but see if he'll talk to his mom, which is wrong.
Right. So our viewers don't know that the video actually continues. And we're going to play more of that. But at that point, when that individual, when that kid said he wasn't willing to answer any questions, that should have been it. End of story. Marty, this is your client. Can you just set up the scene here? Tell us what the child was charged with. We see the officer reads the child his Miranda rights, then leaves the room and comes back with a different approach. What's going on here?
Well, let me just emphasize, when we say my client, it's this youth was being represented by an attorney on our staff at the Juvenile Rights Practice of the Legal Aid Society, but I personally didn't represent this youth. This youth was the youth was charged with I believe it was possession of a weapon, and obviously, a serious crime. And as Cheryl was just saying, this officer was determined. He wanted this statement. He wanted a confession, and he was not happy with the response that he got, and he was going to get some input from somebody else to try and find out what he could do to approach this differently. But that should have been the end. Under the law, the youth said no, and unless the youth at some point or another says, I changed my mind, I am willing to speak to you, that's the end of it. There should have been nothing further.
All right, so I'm going to play that third clip now, and I'm going to get your thoughts on the back end, Cheryl.
Okay. All right. You understand why you're in here?
Yeah.
So, Do you want to talk about it, or you want to ask them what's going on, or why are you in this predicament?
I don't even know the story, what happened. You know,
You want to ask them what happened?
yeah, what happened?
I was in a store ordering my food.
Oh my God, Cheryl. So the officer, like you said, is using mom to assist in the interrogation. He seems to be effectively questioning the boy through his mother, even though the child already said he didn't want to answer any more questions. It's not ethical.
Yeah, and you know what's unfortunate is that it's very easy to take advantage of someone who's never been in a situation like this. And you can imagine, as a parent, and I'm one, you've got your teenage child in an interrogation room. Lord knows what's going to happen, and you want to ultimately leave with that child. And so, yeah, I want to know what's going on, but that is not the time to have a discussion, not only in the officer's presence, but when he left the room. And I don't know whether or not they did have a conversation. People need to understand, when you're in a police car, when you're in a police facility, just assume that you are always, always, always being monitored and recorded, and you should say nothing.
All right, guys, you two are not going to be going anywhere. We have to go to a commercial, but folks, don't change the channel. We have more on this case and more to break down in that video when Making the Case returns. Welcome back to Making the Case. I'm Yodit Tewolde. Still with me, Marty Feinman, and who's head of juvenile delinquency training at the Legal Aid Society's juvenile defense practice in New York. That is a mouthful, y'all. And Cheryl Dorsey, a retired LAPD sergeant. All right, so I'm going to play now a final clip of that video of the young juvenile that's being interrogated by police.
All right. Anything you want to talk about, Mom? Is there anything you want to ask them?
I just want to hear what he's sorry.
Still in federal? So just need you to sign it. Yeah. I'm not you anymore. It's fine.
Yes, I am.
Stating the questions I read off to you.
Okay. Start signing.
That's good?
Take your time.
Good. Mom, I just need you to slide over here real quick and just sign in there.
Here.
Right where the X is at.
Okay, so Marty, clearly the 13-year-old said no in the beginning, that he wasn't willing to answer questions, but now the officer is getting mom to sign a waiver of the Miranda rights that are owed to her son. Obviously, this is illegal. Is your legislation that you have drafted going to protect juveniles from this type of technique?
Absolutely, because that never could have happened. If our legislation is passed, the first thing that police officer will have to do, if he wants to be able to question that youth, is he will have to put that youth in touch with an attorney. That attorney will have a conversation with the youth. That attorney will probably ask to speak to the police officer that wants to speak to the youth. That attorney will take in all that information, size up the situation professionally, thoroughly, and advise the youth as to what the most appropriate decision is for him to make. And in almost all circumstances, unless there is a concrete benefit being offered by the police to the youth, which rarely happens, the likelihood is that the attorney is going to counsel the youth not to waive his right to remain silent. And if by some chance the youth was going to waive his right to remain silent, the attorney would make every effort to be present and be a part of it. So something like this kind of abuse could never take place.
Cheryl, what type of advice would you give to parents who want to protect their children in situations like this with police?
Never have a conversation without the presence of an attorney. You can't trust police officers. And listen, we've seen time and time again when an officer will purport a thing and we know that it's not true because great deference is given to a police officer's version. And if you don't have the evidence to prove that something untoward happened, 9 times out of 10, it's their word versus yours. And if you have any sort of a criminal history, then what you have to say is very easily refuted by that police officer. So no matter what anyone thinks about you not speaking, it's always best to never speak to yourself, because folks have had conversations with themselves in a police facility. Don't speak to anyone else, and do not speak to a police officer without the presence of another attorney. Because we've also seen when officers get you, they will keep you for hours and deprive you of sleep and maybe in sometimes food.
Yes.
And you'll say anything to get out of there at that point. So say nothing.
Say nothing, drink nothing. I mean, sit on your hands and just wait. Marty, tell us how this case was resolved, and did anything ever happen to those officers?
As far as anything having happened to those officers, not to my knowledge, and quite frankly, particularly the officer conducting the interrogation, probably should have been investigated by internal affairs. Maybe charges should have been brought against him because he essentially had them sign documents under false pretenses. What happened in that case, and here's part of the tragedy of this case, well, tragedy. One of the most disturbing aspects of this case is that not only did the police officer engage in the kind of conduct that he did, ignore the youth's refusal to speak, co-opt the parent after getting assistance, probably when he walked out of the room, from a superior, a supervising officer who would have told him and helped him figure out what to do. Co-opt the mom to get the mom act as his assistant, essentially, against this youth. And then begin to question the youth directly himself, then have them sign this form suggesting that the form says that he waived his right to remain silent when he never did. And then what happened is the prosecution's office in family court provided the defense attorney with notice of the fact that this statement had been obtained and that they were going to use it against this youth in the case that went forward. So they presumably,
Hey, Marty.
if they, yes, I'm sorry.
Marty, I've got my producers in my ear saying we've got to go to commercial, but I definitely will invite you back to have a conversation about juveniles in general. I used to defend them, and they're definitely a passion of mine, so we'll have you back. Marty Feinman, head of Juvenile Delinquency Training at the Legal Aid Society's Juvenile Defense Practice in New York, and Cheryl Dorsey, of course, lovely to have you, retired LAPD Sergeant. Thank you both.